Welcome back to our mini-series on debt sales. I'm Chris Eastman from Franklin Ross Strategies. I'm excited to be back with Joseph Schuster, partner in financial services practice at Ballard Spahr for episode 4. In episodes 1 through 3, we focused on the big questions surrounding debt sale. What is a debt sale? Why companies might sell debt? Who buys the debt? And how sales are structured. Today, we're going to discuss the current regulatory landscape for debt sales today. Joseph, I know you spend a lot of time thinking about and advising clients on this topic. Why don't you start us off by giving us your view on the current regulatory environment?
Thank you, Chris. I appreciate you doing the introduction. I know that you're concerned that I'm going to be talking too much about the regulatory legal risk that we have today, so appreciate you adding that in.
Well, I'm calling this one affectionately the Joseph episode, so I'm going to let you take it away and do what you do best.
I like it. From a legal perspective, the regulatory environment for debt sales, I'd say, is best described as fragmented. It's more active, it's more consequential than it has ever been. Debt sales themselves aren't new, as we've been talking about for the past 3 episodes, but the scrutiny around how debt is transferred, collected, and enforced has increased significantly, primarily at the state level and with respect to plaintiffs' counsel. This is something that you and I discuss a fair amount, that the CFPB has stepped back in this space currently. Now, that said, if there are changes in the CFPB, and we are starting to see swings in the CFPB from one side to the other, so what is happening now is not going to go without scrutiny by the CFPB in the future. So it is still a consideration. But given the current swing with respect to where the CFPB is, we are seeing states become more and more active in this space. Where we used to be primarily concerned about one regulator, we are now more concerned about a much more numerous set of regulators at the state level, both specific agencies and states' attorneys general. So it's created a much more complex environment for debt sales. There is more appetite now, I'd say, because you do not have the headline risk at the federal level that you used to have with the CFPB, but we're more maintaining more of a state level matrix of where there are specific risks with states. We're looking at that from the seller side, and buyers are also looking at it. We've had deals where debt in specific jurisdictions, a specific state is carved out. It's priced differently because of the regulatory risk within that state. That is not something that was as common, I'd say, 6 months ago, a year ago, certainly 3 years ago, 5 years ago. So there has been a lot of changes in this. One important shift is that regulators are no longer just focused on collectors either. They're increasingly looking upstream. They're looking at sellers. They're looking at the documentation process and whether the risk is appropriately being managed at the point of sale. And I'd say at the diligence. We have a structure that we generally follow with these, that we work when we're working with our clients are selling debt, from the RFP process to the initial diligence questions to on-site diligence questions to what the provisions that we have in the purchase and sale agreement from a regulatory perspective. Now, obviously, we adjust those. Different clients have different risk profiles and different considerations and concerns. But having those different things, having that memorandum of the diligence that has been done, being able to share that with regulators, or a summary that we can put together that's shared with regulators, is more important now, as there are more questions being asked, because consumers will file complaints. Those get filed now with state attorneys general, and state attorneys general will look into those claims. Having the process documented and having all these things that you're able to share in response, I would say, is more important now than ever. All right, with that headline, I'm going to say that there's a few consistent themes that I see across jurisdictions. First is documentation and chain of title. Regulators and courts, very important on the courts level too, there's a lot of plaintiff counsel risk with these, are focused on whether the buyers can demonstrate ownership of the account and the right to collect. Gaps that may have been tolerated historically, where the person you had where the debt was created, now this other entity owns it and you're able to collect on it, and there was something that happened in between. That wasn't as much of a concern later. Now there's a real litigation and enforcement risk if those gaps exist. So that chain of title is very important. Second is product-specific scrutiny. Here's where I could have really blown this episode up into a 2-hour episode, and Chris has kept me to the confines of the mini-series that we are doing. But I would say that medical debt, student loans, certain specialty consumer products are subject to evolving rules that directly affect their collectability and valuation. There are a lot of different types of debt that is being sold right now. We work on different types of debt that wasn't being sold a decade ago. And I do think that where there has been a difference or a benefit in the debt sales market as a result of the pullback in the CFPB recently is that certain types of debt that were not historically being sold or that were maybe prior to the inception of the CFPB, those are starting to come back onto the market now. Again, there is still that scrutiny at the state level. If the CFPB has changes in the future, will those be subject to evaluation? Certainly. However, they can be done correctly, and we are working on those so that when they are evaluated, there's not going to be there's less likely to be risk that's found with those. And I think that there is a benefit that those are coming back to the market, that if there is a shift in the CFPB, they will likely continue to be back on the market. And we are seeing buyers have more appetite for those types of things as some of that debt is starting to hit the market. I'd say that third, there is UDAAP risk, consumer experience risk. This is a difficult concept, this third one, for me to kind of come up with what exactly to call it. But this is where what we put into the contracts, into the documentation is really important. Even if a sale is technically valid, regulators are increasingly focused on whether consumers are treated fairly post-sale. That's where those complaints are very important. Regulators are looking at whether sellers have exercised appropriate oversight in selecting the buyers and in the terms in the commercial agreement. And that is something that we look at a lot. What are those terms? What are the oversight terms that are in there? What do you have in terms of audit rights? Again, what's in the documentation is what is being looked at by regulators, by attorneys general. What is written is very important now. So, and this is something that's been evolving for some time, and I think, Chris, you've probably seen this, is that debt sales are not a clean break from a regulatory responsibility. And we had guidance from federal regulators quite some time ago about this as well, and that affected the industry back then, probably about 15 years ago or so. But it's continuing to evolve now, and I'd say that representations, warranties, repurchase obligations, buyer vetting, diligence, all of this matters a lot more than it used to, just continually more and more. I think that this matters. And the documentation around all of those is really important. I think that a well-structured sale allocates risk clearly. It reflects realistic compliance expectations. It aligns incentives so that both parties are operating within the same regulatory framework. As I've been saying, we have a very specific process that we follow with our clients that generally is successful and works well for them when there are inquiries later on. That RFP process, the diligence process, documenting that diligence process. Additionally, the terms that we use in our purchase and sale agreements are carefully tailored to protect the seller, protect the transaction, but also to address what regulators are expecting to see. So, Chris, I've just talked a lot in general, but I've talked a lot about how the regulation is kind of evolving. I'd be curious for your thoughts on that evolution that you've seen, the debt that's being sold and where sellers and buyers are. But I'd also be particularly interested in your perspective on how these regulatory developments are affecting the economics from a buying and selling perspective.
Yeah, Joseph, I think you did a really nice job of laying out the regulatory framework that we're seeing in the market right now. And specifically, when you talk about increased activity at the state level, I think this is where we see a lot of impact on economics. If you think about it from a buyer perspective, it is a lot easier to comply with one federal set of regulations than it is to comply with potentially 50 different state regulations. And then you even see locales or cities passing their own rules and regulatory requirements, all of which really make it more difficult to comply with, more difficult to collect, and more difficult to really maintain oversight of as a debt buyer. And those cost increases ultimately get passed on through the purchase price that a buyer is able to bid for a debt sale. And so what I would say is like there's a couple of specific markets, medical debt and student loan debt, which have seen significant changes in a regulatory environment over the past few years. On the medical debt front, a number of states have come in and passed laws that limit credit bureau reporting, may limit the use of legal collections on medical debt. And some others have passed restrictions to shorten the statute of limitations. Now, all of these things have created a lot of headwinds into pricing for medical debt. So what we've seen is really twofold. One, pricing for medical debt can go down in some cases by as much as 30% as a result of some of these regulatory changes. And then number two, you're seeing a lot of traditional medical debt buyers look at exiting the space altogether because of the compliance environment and the regulatory environment and the headwinds to ability to collect on the debt. The student loan side has been a little bit different. We've seen a lot of activity at the federal level to suspend credit bureau reporting, to suspend collections or payment due on some of these student loan obligations. And then administrations have even gone so far as to forgive medical debt outright. And this has really created a lot of uncertainty, I think, commercially from a debt buyer perspective. And as a result of that uncertainty, you're seeing a large drop, again, in pricing for student loan debt. And then a lot of players who might have considered buying student loan debt traditionally are now pausing or exiting outright the student loan space altogether. I think conversely, Joseph, there's one thing I'd like to highlight, and that's in the BNPL space. It's a different story here, right? As more BNPLs get comfortable with the idea of credit bureau reporting, I really see this as an opportunity to increase pricing on the debt sales side, as that becomes more commonplace, and that becomes another lever or opportunity for debt buyers to gain value on the debt that they're purchasing. So it's definitely, from a commercial perspective, a multi-pronged or multi-sided thing to think about. But Joseph, as you think about these items and these risks and these considerations, how do you incorporate these issues into the sale contract to make sure that the buyer is properly protected?
It's a great question, Chris, and it's a very, I find it as a fun process as we look at these. I have a whole library of different purchase and sale agreements, and depending on the deal that we're working on, trying to figure out what's the best starting point template for the client for the transaction that's taking place. There's probably three categories that I'd say are very important. And you're probably going to have something to say about this first one in particular, and that's restrictions and limitations by the seller and by the buyer. So as we talked about these regulatory pieces, we've talked about how the buyer will have specific types of debt that they are saying that they are buying and excluding other types of debt that has been impacted by fraud, or that was certainly debt that was created through fraud is going to be excluded. But the buyer might have additional restrictions on what they're going to purchase. The restrictions by the seller. This is a very important one for our clients, as we're representing a lot of sellers. And that is what the buyer can do. You've talked about credit reporting. There are some types of debt and some sellers of those types of debt who do not want that debt to be credit reported. That there were certain things that they may have agreed to or marketed or discussed with the product with respect to their customers to make sure that there aren't any things happening downstream with that. They'll put those limitations in the contract as well. I know you'll say that this will impact pricing, and we've worked on deals where you're like, hey, if we really do this restriction from a regulatory perspective, it's going to have this type of effect on the price. So those things, there are commercial considerations here. That is certainly understood. The second one that I'd say is with respect to the indemnification provision. This is a big one in terms of what is covered and to what extent. You will have caps on the indemnification. You'll have baskets with it. There will be exclusions for specific regulatory items, but this gets negotiated a lot in these agreements. And different things will be important, more important or less important based on the transaction, the parties that are involved. So this one does vary a fair amount, I would say. And then the third one, this is the one that there are a lot of provisions that are expected by regulators in some form or fashion. And we've been including those provisions, and they get modified in the margins, certainly. But as these agreements do get reviewed and by regulators, it is important to have certain things so that you're showing that the seller is doing the proper level of diligence, that what is being sold can be sold, that chain of title, that the buyer is only buying the types of debt that they should be buying. But there are a lot of specific provisions, from privacy, from transferability, a lot of things that I guess some would call boilerplate. I call it fun, but we have those in all of those purchase and sale agreements I was talking about in the library that as we start these transactions. But Chris, anything that you would add to those things as we're talking about putting together that purchase and sale agreement?
Yes, Joseph. I think you hit the nail on the head with the first one, which is anytime you're putting constraints on what the buyer can do from a recoveries perspective, you're going to see a price impact. And I know you've worked with me on some deals where I've told clients it could be a 50% price reduction if they choose to put certain limits on what the buyer can do from a collection perspective. So that's really something you want to weigh the benefits and the risks of as it pertains to what you're trying to accomplish in your debt sale. The other thing I'd love to get your thoughts on this, when it comes to reps and warrants, these really, in my mind, there's product specific items to consider here. And then there's also, historical regulatory issues that a company may have dealt with as a seller that may bear themselves out and how some of these reps and warrants are negotiated. And so having, a really good knowledge set and expectation going in to the contract around what the buyer is probably going to be thinking about in terms of making sure their risk is reduced based on previous regulatory actions is probably something, Joseph, you help sellers think about all the time.
Absolutely. And I think it's a good transition. I think we're going to get into that in a lot more detail in our coming episode, but it goes to that diligence of the seller understanding what they're selling and the seller's diligence that they have on their portfolio so that we can understand what we can include with reps and warranties. We obviously want to limit these as much as possible for the sellers, but where we can include those reps and warranties and where we need to have hard lines on them. But it's a fascinating question. It does get discussed a lot. With that, I had promised that this was going to be one of our shorter episodes because it wasn't going to get into the specific products. It's gotten a little bit longer because I couldn't help myself. It's a great topic. I think we'll close it out here, though. I'd say that as we think about this episode, regulation isn't just a legal backdrop on debt sales anymore. It's a central driver to pricing, structure, and buyer participation, as we've been discussing. Understanding that landscape up front is critical to executing the deal that delivers the value that you're expecting. Again, in our next episode, we're going to build on this by talking about how sellers can prepare for a debt sale, what they can do before going to market, how to avoid some of these common missteps that Chris and I have been discussing, and how to position a portfolio for the strongest outcome. Thanks for listening.